The Electoral Commission is asking the Supreme Court to dismiss the petition brought before it challenging the outcome of the 2020 presidential election, which was declared in favor of Nana Addo Dankwa Akufo-Addo, describing it as a total waste of the court's time. In a preliminary objection to the petition, the EC explained the case of the petitioner is founded on two assumptions it maintains are wrong. Court correspondent Joseph Akable has been going over the preliminary objection filed on Friday and joins me with more. Now, Joseph, what are the main arguments the EC is basing its call for the dismissal of the petition? All right, Joseph, you have to unmute. All right, it looks like we can't quite hear you. So we will come. Hello, Joseph, can you hear me?
Hello, Israel, can you hear me?
Yes, I can hear you now. So yes, I was asking what is the basis the EC is basing its argument on?
The Electoral Commission says that the petition is based on extreme speculations, and these speculations are based on two assumptions that the Commission says are wrong. The first is that the EC says Mr. Mahama relies on wrong figures. That is the 13.4 million that he uses as the total vote cast, even though the correct figure of 13.1 million is known. And the EC says in its declaration, it's inadvertently used 13.4 instead of 13.1, and it has since corrected that. But Mr. Mahama still relies on the 13.4 million in this analysis, and so the Commission says that is one speculation that the petition thrives on, which is inaccurate. The second point says that Mr. Mahama adds all the Techiman South results to his, i.e. the total voters in Techiman South to his results to make the case that if that transpires, it means no candidate got more than 50% of the vote cast. The Electoral Commission argues that that is also another extreme assumption that is not accurate, in the sense that the votes obtained by each of the candidates who contested the 2020 post for Techiman South constituency is known, and that in actual sense, Mr. Mahama in his petition attached the results from Techiman South to his petition, and so he knows the results for Techiman South and should have used the actual results instead of making assumptions on the basis of results that are known. He goes on to conclude by saying that the petition fails to disclose any reasonable course of action, and as a result, is a complete waste of the court's time and should be dismissed as soon as possible.
Now, also explain to us, Joseph, where this preliminary objection features in the scheme of things following the timeline set out by the Supreme Court earlier this week.
On January 20, when the Supreme Court fixed the timelines, it did indicate at point E of that particular directive that it's issued that the ruling on the preliminary objection will be incorporated into the main judgment. And so for those who were expecting that this will be dealt with and will have a decision as to whether or not a trial should take place or not, the court is actually saying that, look, there's an initial objection, but I'm going to proceed with the trial and rather incorporate the decision relating to the initial objection as part of my final judgment on the petition itself. So as it stands now, this initial objection, unless the court decides otherwise, per its directive on January 20, the case will proceed as this initial objection remains outstanding and to be incorporated in the decision of the court on the petition itself.
Now, Joseph, how many of these expectations have been met by the parties, especially because we know the petitioner made it clear he wouldn't be filing the witness statement?
In fact, this document that was filed by the Electoral Commission today forms part of its quest to comply with that particular directive. We understand the other respondents, the president's side, have also gone ahead to file the witness statements and the other documents that they are supposed to file, at least per the indication they gave us prior to the close of the day that they were going to comply with that, and that they are not perturbed by the decision of the petitioners not to comply with that directive. The petitioners explained that it is a principal position that they have taken, in that they are simply filed a stay of execution, reminding the court that, look, don't proceed with your case because we are asking you to take a second look at your decision that could have the potential of changing all proceedings that take place. And so on Tuesday, they will bring this to the attention of the court to inform the court that as a result of the pending review that is due on Thursday, do not have the proceedings on Tuesday till we come on Thursday for you to deal with that as well. And the court will have to decide whether or not to grant that stay or not. What is not clear at this stage is, in the event the court opts not to grant the stay, will the petitioners be ready to call their first witness, or will they be ready to open their case for the petition to continue? This is an important question that we can only have answers to when we go to the court on Tuesday.
All right, thank you very much, Court Correspondent Joseph Akable.